Good afternoon, everyone, and welcome. I see faculty here, staff, students, community members and advocates from the bar, and friends of the law school. I'm delighted to have all of you here today. I'm Bill McGeverin. I'm the Dean of the University of Minnesota Law School. And we're gathered here for an important occasion in the life of a law school, which is the investiture of a named professor. Today, Linus Chan, professor of clinical law and the director of the Detainee Rights Clinic, is invested as the James H. Binger Clinical Professor of Law. Congratulations, Linus. So at the conclusion of the lecture, I hope you will all join us upstairs, one level up in the direction of the main doors, in Auerbach Commons for a reception with light refreshments, and we can all congratulate Professor Chan in person when we're there. I know you're all excited, as I am, to celebrate Linus and hear from him today. This occasion, the occasion of an investiture, gives us all the opportunity to celebrate our incredible intellectual community here at Minnesota Law, including, of course, centrally, the central contributions of our faculty to that intellectual life. The James H. Binger Clinical Professorship of Law was created with a generous gift from the Robina Foundation to support outstanding faculty members in the law school who are engaged in clinical instruction within the James H. Binger Center for New Americans. As many of you know, the Robina Foundation generously endowed both this professorship and BCNA in 2017 with a transformational $25 million gift, which is still the largest in the history of this law school. The Robina Foundation was created to invest in the vision of its founder, James H. Binger, a 1941 graduate of the law school. He was a distinguished leader in business and philanthropy in Minnesota and around the world. And today, with the efforts of our extraordinary faculty, as well as our staff, our students, and our robust community partners, the Binger Center protects and advances the rights of non-citizens in the United States through advocacy, litigation, and community education. Collaborates with clients, with both law firm and advocacy partners in the community, faculty and students, using the institutions of law and of higher education at this great university to help foster an inclusive community that treats everyone, including non-citizens, with dignity and agency. That is a very extraordinary mission statement, and that is the mission of the Binger Center for New Americans. We are so grateful to the Robina Foundation and Mr. Binger for their generosity and their investment in the law school and in the Center for New Americans. Here at Minnesota Law, Professor Steve Miley previously held the Binger Chair, and today it's my pleasure to formally welcome my terrific colleague Linus Chan, Professor of Clinical Law and Director of the Detainee Rights Clinic, as the new incumbent in this role. Professor Chan joined the law school in 2013 and was promoted to Clinical Professor of Law in 2023. He is an immigration attorney. He focuses on removal defense for those detained by Immigration and Customs Enforcement. He also teaches both in the clinics and in other parts of our curriculum in the areas of the intersection of criminal law and immigration law. He is widely recognized for his work on behalf of his clients and for his stellar work with his students. From 2021 to 2023, he was the law school's Vaughn G. Papke Research Scholar, say that 5 times fast, and was awarded the law school's Stanley V. Kenyon Clinical Teacher of the Year Award twice in 2016 and then again in 2022. Additionally, he's published articles in the Albany Law Review, Law and Social Inquiry, the Journal of Race, Gender, and Social Justice, and the Valparaiso University Law Review. Professor Chan holds an AB from the University of Chicago and a JD from Northwestern University School of Law. In 2020, he was honored by the National Immigration Project. His skills in and passion for client advocacy, student mentoring, and fostering partnerships with the community truly make a difference in the lives of so many here at the law school and in immigrant communities throughout Minnesota. Now, as some of you know, we typically present a gift during an investiture. Linus, if you'd come up, I would like to present bookends engraved with Linus's name and his new title, with which to hold up shelves of books. We all could use more bookends in our lives as the people of the book, the scholars that we are. Friends, faculty, students, and everyone here, please join me in congratulating Professor Linus Chan.
Thank you, Dean McGovern. Thank you very much, of course, to all of my colleagues at the James H. Binger Center, and not only current, but past colleagues, such as Ben Casper, who happens to be here, my students, former students, people I've worked with within the community, and others. It's very both daunting and gratifying to see people in this room and all here with the promise that I might say something interesting. So when I first heard that I was supposed to give a lecture, this was, of course, the way that I wrote and thought about, academic titles, and I wrote this title. Of course, as the election season has worn on, the title kind of got changed a little bit, and then this last one, which is Deportation Sucks for everyone, even citizens, and in fact, if I were to be quite honest, I would have another title, but of course, I don't want to dishonor this law school. So instead, of course, I do want to give a real big shout out to Sarah Broadwolf, who is my research assistant and was invaluable in helping me put together this talk. So what are we going to talk about? Well, this is a picture of me and my law students when we went to the immigration court. Now, last year, we had gone to immigration court in order to do intakes with people who were about to have their first hearing in front of an immigration judge. And it was, in fact, one of the things that I've been doing for about 20 years now. I've been an immigration attorney for 20 years. In fact, I would say I am not really quite an immigration attorney. I am a deportation attorney. And where this court happens to be situated is, I think, important for us to acknowledge right away. Because where deportations happen in the state of Minnesota happens to be in the federal building, the Bishop Whipple building, in Fort Snelling, Minnesota. I didn't know much about Fort Snelling. It took a while before, probably 6-7 years, before I realized the significance of Fort Snelling here in Minnesota. And it's important to recognize that it was, in fact, the location. It was the primary military outpost during the U.S. Dakota Wars. It was the concentration camp that was used for women and children that were part of that conflict. And so these were the same people who, by the way, back in 1862, were also not considered citizens. And they were also being detained in a war between the U.S. military, and it was through Fort Snelling and that place where the U.S. military not only fought and killed combatants, executed the largest number of public execution to date in U.S. American history, but also canceled treaties and took land. So I thought it's important to at least start with that, given that yesterday, of course, was Indigenous Peoples Day. All right, it's only going to get even more grim for a little while. I hope to be a little more positive as we go on. So there are going to be two quotes that I'm going to start with. And they are two quotes that have a different vision of what it means to be a citizen. And I want to just state, too, being a deportation attorney, which is, in my job, I am seeing people who are being held in detention, who the U.S. government is trying to deport. And my job during that work, it has forced me to confront what it means to have U.S. citizenship. Because most of the time when I'm talking to somebody, and I'm not going to pretend that the people that I talked with are exactly like me or that we shared a vast amount of commonalities, but the only legal difference, the only difference under the law happens to be that I am a U.S. citizen and they are not. And at the same time that I'm trying to prevent people from being deported, I'm trying to get them out of detention, I am become keenly aware that that legal distinction is all important. But why? What is it about citizenship? So this is a quote from an article called Citizenship in the American Constitution, and it's a quote by Alexander Bickel. For those of you who may not be legal scholars, law students, or just legal nerds, Alexander Bickel might not be a very familiar name. But he was a law professor at Yale. He was also, when the Federalist Society was trying to figure out what to name themselves, they had seriously considered naming themselves the Alexander Bickel Society. He was instrumental. He was a clerk to Felix Frankfurter, and he was a clerk during the time of Brown versus Board of Education. And this was his vision of citizenship when it comes to the Constitution. That citizenship, which is a concept, matters very little. That it is a simple idea for a simple society. On the other hand, this is actually taken from a dissenting opinion from a case called Perez versus Brownell. Now, the picture does not happen to be a Supreme Court justice who wrote the opinion. This picture is of Hannah Arendt. And the reason why I put her there instead of the man who wrote these words is because consistently the Supreme Court keeps quoting her and not actually giving her any attribution. Not too surprising. But this is another vision of what citizenship means. And in this vision, citizenship means everything. The right to have rights. Now, to be fair to Hannah Arendt, when she wrote that statement, it was in response to the Universal Declaration of Human Rights. And she was critical of the Universal Declaration of Human Rights. She was critical because she believed that whatever international body that was trying to support the idea of human rights, it needed to understand it, it needed to ground itself in the idea that only nation states could actually enforce those rights. So what she meant by citizenship is a person's basic right to have rights was the idea that if we are going to go anywhere, then you need to understand that people have to have the right to have political membership. Okay, so not everyone in the room are lawyers or law students, so I think I'm going to go really quickly, and of course, if you haven't taken 14th Amendment with Jill Hasday, even if you are a practicing lawyer, I hear you should probably still take her class, sit in perhaps. So constitutional rights, there's sort of two dividing lines. One is pre-civil rights, one is post-civil rights, and the idea, of course, is, hey, it's the rights that are enumerated in the Bill of Rights. It's also, Article 4 talks about privileges and immunities. There is the idea of course, unenumerated rights. That was concluded in the Due Process Clause of the Fifth Amendment, pre-Civil War days. Post-Civil War, we've got a new player in town, and that's the 14th Amendment. It's extremely important because not only did it define new rights, one of equal protection, but it also was the creator of national citizenship, birthright citizenship. It did not exist, and it was left undefined until, of course, Roger Taney decided the Dred Scott decision, which we'll touch upon in a little while. All right, so in Bickel's world, why does citizenship not matter? Well, the first thing he talks about is that these rights, the enumerated rights in the Bill of Rights, uses the words of the people. The First Amendment talks about it. It says, or of the right of the people peaceably to assemble. The Second Amendment, the right of the people to keep and bear arms. The Fourth Amendment, the right of the people to be secure in their persons. In two other forms of enumerated rights, which is the Due Process Clause and later on the 14th Amendment, not only do they use the words person, any person. Due process says, nor shall any state deprive any person of life or liberty. Those life and liberty has become the source of what's called unenumerated rights, at least for now. Equal protection was also supposed to be given to person. It doesn't use the word citizen. Now, we got confirmation that the word person means person through two cases following the Civil War. The first case to the left is a case called Yikwo versus Hopkins. That had to do with a Chinese laundromat, and California wanted to go ahead and prevent those businesses from operating. And the Chinese laundromat owner said, hey, you just passed the 14th Amendment. I am supposed to have equal protection under the laws, and it says person, and the Supreme Court of the United States said, you're right. Great. The next case is called Yamataya versus Fisher. It's called the Japanese immigrant case. Well, actually, there was another Japanese immigrant case, but this was one of the Japanese immigrant cases. This not only is it person, but the claim here by the UN, by the Commission for Immigration, was that Ms. Yamataya was not authorized to come into the United States. She was, in fact, considered an undocumented immigrant. And what did the Supreme Court say? Well, it said, even though this person may not have the right to enter the United States, because due process attaches to the term person, there has to be some due process protection, even for those who are unauthorized to be here. Whoops. Oh, how am I going to go backwards? Now, I want to make sure that we're clear about something. When Alexander Bickel wrote that citizenship did not matter, he did so in an article in 1973. It's important to understand the context of that time. In 1973, Roe had just been decided in January. Substantive due process was king. Prior to that, in 1971, the U.S. Supreme Court had decided a case called Graham versus Richardson, which had explicitly said that states could not discriminate based on citizenship when it came to state welfare programs. In fact, there was a line of cases that happened in the early 70s in which the Supreme Court basically said any states that were trying to restrict hiring to citizens was not allowed. And in one decision, Sugarman, there was a situation where they called it invidious discrimination to prevent non-citizens from working. So there is good reason why Bickel in 1973 was able to look out into the constitutional landscape and say, citizenship doesn't seem to matter. Due process is acquired for people who are non-citizens. Equal protection You cannot discriminate based on someone, based on citizenship. This is a good way to think about why our Constitution doesn't care about citizenship. So why are we here? Why have we started to hear all the talks in the election season about what to think about immigrants and non-citizens? I think one reason why is this number. In 1973, there were 17,000 deportations for the entire year. 17,000. In 2023, there were 340,000 deportations. Now, to be fair, by 1973, the actual framework, the constitutional kind of authority for deportation had already been set up. But the logistics, the actual movement and forced displacement of people from the United States was happening on a relatively small scale. Your next question might be, well, what about the border? Again, border enforcement in 1973 was very low. There's a great podcast, if you like podcasts, called Revisionist History, that talks a little bit about how little enforcement there was on the border in the 1970s. So when Bickle was making his statement that citizenship did not matter, he could do so in a way because he didn't really have to think very hard about deportation. In fact, in his article, he talks about deportation as something about international diplomacy. And it wasn't really what mattered. So let's talk about the deportation power. Now, there is some really great scholarship about what deportation might have looked like prior to Reconstruction and the 14th Amendment. But most of the time when we think about the federal deportation power, it begins with the Chinese exclusion cases and what's called Chai Ping, in which the Supreme Court recognized that, hey, we have the authority to exclude based on sovereignty. And by the time they decided, in this case, Feng Yuting, they decided that the authority to exclude also meant the authority to expel. It's important to understand the context here. This was a law passed in the 1880s. The 14th Amendment had just been passed 20 years earlier, in 1868. The framework, the foundation of the 14th Amendment was, hey, no racial discrimination. What did Congress do in 1880s? They said no more Chinese. Was it racially discriminatory? Absolutely. But why and how did the Supreme Court say it doesn't matter? Well, the Supreme Court, one, said, hey, guess what? This is the federal government. 14th Amendment isn't supposed to restrain the federal government. And second, despite the fact that there were some treaties signed, that doesn't really matter. No surprise. What we are going to say is, hey, we have the power, and not only does the federal government have the power to deport people, it is not constrained. It is a plenary power. And the word here that does a lot of work is whenever. Now, over the years, the Supreme Court has, over the years, found other ways to think about deportation power, right? It's essentially been a bit of an exception to what we would consider constitutional protection. You could be deported based on race. You could deport you for things that you did before the law was passed. No ex post facto protection. So there were several cases in which someone who came into the United States, they did certain things that was totally legal, would not get them in trouble, but then later Congress said, you know what, if you did those things, you're deportable. People said, wait a minute, when I did them, I wasn't deportable. Why isn't this an ex post facto law? And the Supreme Court says, well, first of all, it's civil, and second of all, it's part of Congress's deportation power. You could also be detained without any individualized determination. This was important. Not only could you be detained without bond, which was something that the Supreme Court decided was possible for criminal defendants in the 1980s, but the Supreme Court went further and said you don't need to make an individualized determination. People can be detained without bond categorically. This is unique. You can be arrested without a warrant, without one that's signed by an independent magistrate. The way that you think about the Fourth Amendment, right? There are several aspects of the Fourth Amendment. One is the warrant clause, but the other, of course, is that it needs some form of independent magistrate to sign off on the existence of probable cause for the Fourth Amendment, for immigration, for deportation, And then, of course, and this came later in the 1990s, you can be deported without a hearing at all. You could be deported with a piece of paper that was given to you. In fact, last week, some of my students and I went to visit a federal prison in Waseca. And many of the people who were held in Waseca were women who had been convicted of certain crimes. And many of them were getting these paper forms of deportation. And it was a really simple piece of paper that says, hey, federal government thinks that you are deportable and thinks you are deportable because of your crime. There is not going to be a hearing. You have 14 days to contest this. Of course, it was 14 days to only contest whether or not your crime would subject you to deportation, and that was that. That was what was allowed. It's hard sometimes when I have these conversations with people in this field, in this work, to sort of talk about how much of a weird, non-constitutional space deportation really is. Things like burdens of proof. Well, in many ways, sometimes they're for the person, but a lot of times they can be switched on you, and you have to prove that you're not going to be dangerous in order to get released. So, what does that mean? Where does that leave us? Well, in many ways, I think some people would be just fine with the idea that, hey, the law of immigrants, which is Bickle's world, was this idea that, hey, even if you're not citizens, you have to be treated equally, you have to be treated fairly, and you have the same rights generally as everybody else, citizen or not, while you're here. But there's also the law of migration, which is we are going to get separate rules for how you come and whether or not you need to leave. And that can be kind of summarized with the law of immigrants versus the law of migration. That sure, the bottom half can be harsh, but the first half sort of kind of promotes this idea of what we have of equality. Everything changes when we talk about poor people. So this line between the law of people who are here already and the law of how to allow people to come in or forced out, well, I believe it changed in the 1970s, right after the time that Alexander Bickle wrote that essay. And why did it change? Well, it changed because of Social Security benefits that were distributed by the federal government. Remember, I had talked about Graham versus Richardson in 1971 had issued a constitutional rule that said, states, you are not allowed to discriminate on the basis of citizenship when it comes to your welfare rolls. Poor people, whether they're citizens or not, they need to be able to access welfare, and it is invidious discrimination for you to deny them such benefits. 1973 rolls around, and the federal agency that's in charge of setting up these Social Security supplemental benefits under Medicare starts promoting a regulation that would say to states, hey, you got to make sure you have to give benefits to everybody. Not only people who are citizens, not only to people who are non-citizens, but you have to do so even for undocumented people. Now, there was some debate. People said, wait a minute, Graham versus Richardson said people who were lawfully here. But people in the Social Security office were like, well, but we think the meaning of what Graham versus Richardson says doesn't really allow us to distinguish between people who are documented or undocumented. This is a chart that basically has what areas had some federal restrictions on aid to poor people and which ones didn't. And you'll notice that none of them did until 1973. What happened? Well, for one thing, word of this new regulation got out. States started to complain. Texas had restricted federal benefits to poor people based on documented status. Now, many states didn't. New York didn't even ask. Most states never even asked. But they didn't like being forced. And so they started to complain. Another thing that happened was Nixon got pissed. Nixon had just lost a political fight about family assistance, and he had started to campaign on the idea of the need to change welfare. And so what did he do? Is he cut a whole bunch of people in those same agencies, including the people who had drafted the provisions that would have expanded and made sure to protect benefits for undocumented people. Instead, what happened was after they reinstalled somebody, the rule flipped. Not only did it go, and this is important, no state was asking for this, but the rule completely flipped. Because not only did the federal government decide that states could restrict, no, they said states had to restrict benefits from undocumented people. And people who, even if they were lawful permanent residents, did not have enough time in the United States. It was 5 years at the time. But what happened? Well, right away, there was a lawsuit. And it was filed in the Southern District of Florida. And in a 3-judge district court in Florida immediately enjoined this regulation. And it did so based on equal protection. Now, the judge that issued the injunction and issued the order wasn't quite sure that it required what was called strict scrutiny analysis, because he wasn't quite sure that the restriction on undocumented, that Graham versus Richardson had gone that far. But what he did do was he said this restriction wouldn't even pass rational basis. It wouldn't make sense. Why, if you are trying to, let's say, save money, why are you singling out people who are undocumented? And the 3-judge court decided to go ahead and stay that injunction. So now, back then, for whatever reason, it was a direct appeal to the Supreme Court rather than going to an appellate court. And the Supreme Court heard the case and decided the case in June 1st of 1976. This is the front page of the New York Times. And you notice the front page of the New York Times on June 2nd, 1976, did not write about Matthews versus Diaz. Instead, it wrote about a different decision that involved immigrants. It wrote about a decision which was a 5-4 decision in which the US Supreme Court struck down again a state restriction on employment against non-citizens. That is what it wrote about, but what was hidden was a unanimous decision by the US Supreme Court in Matthews versus Diaz, and this is what the case said. Congress regularly makes rules that would be unacceptable if applied to citizens. The exclusion of aliens and the reservation of the power to deport have no permissible counterpart in the federal government's power to regulate the conduct of its own citizenry. The fact that an act of Congress treats aliens differently from citizens does not, in itself, imply that such disparate treatment is invidious. What is it saying? It's saying that because, hey guys, we can deport non-citizens, that means this idea of classification of non-citizens can't always be invidious. Now remember, this was written by Justice Stevens for a unanimous court. He had just written the decision that talked about equal protection when it comes to states. It was this justification, the idea that because the federal government has the deportation power, then of course it can treat non-citizens differently. But I want to sit here for a second. Did the idea of putting people on supplemental Social Security have anything to do with deportation? No. But the deportation power was used to justify different treatment. Now, in the years since this case, several things have developed. 1977, Jimmy Carter tries to pass an act called the Alien Adjustment and Employment Act. What did it do? One, it would have given status to a bunch of people who were undocumented. The second thing it would have done would be to make it illegal to hire undocumented people. Before this case, it was not illegal to hire someone who was undocumented. It was not illegal, in other words, for undocumented people to work. Now, Jimmy Carter didn't get it passed in 1977, but Reagan did. That was part of IRCA in 1986. Since this case, there have been a whole line of new ways in which citizenship actually can matter to the different people involved. And I want to talk about two big cases where it comes up the most frequently, or most consequentially. For those of you who don't know, that's Madison. I think everyone knows. I think that's Jefferson. So this is a case that involved, it's called Verdugo, Euclides versus the United States. And in this case, it was a decision about whether or not the US government had to get a search warrant after they had arrested a Mexican national in Mexico, right? He was living in Mexico. They were able to get Mexican authorities to bring him up, extradite him, arrest him, and have him sitting in prison. But then the US government wanted to search his house. So DEA agents arranged for Mexican authorities to go into his house and search it. They did not ask for a warrant, and they did not get a warrant. And the case went up to the US Supreme Court, and the case was, does the Fourth Amendment apply? Now, in this case, the majority said, no. Why not? Not in US territory, and this is important, because in a prior World War II case, in which involved spouses of US citizens who were overseas during a war, there was some debate about the application of the Constitution overseas. There was a question about whether or not the fact is did they need a warrant because he was in the United States imprisoned? And the Supreme Court in that case said no. In fact, the majority decision tried to make it sound like it was an easy call, right? He's not in the United States, and guess what? Why would the Constitution apply to someone, and this is important, who doesn't have any connections to the United States? Verdugo cites to Matthews versus Diaz, and it cites to it for the proposition that, hey, if you're not a citizen, we don't have to treat you the same way. It talks a little bit about the idea that, hey, the Fourth Amendment, remember, it uses the word people. But the court introduces the idea that people doesn't mean person. What does people mean? It means potentially citizens. And in fact, Rehnquist in his decision says, point blank, that if we were presented with a question about whether the Fourth Amendment applies to someone who is illegally in the United States, we don't know how we would come out, but that's not quite the question that's presented at the time. The second case explicitly goes into this word people, and that is the Heller case. Heller versus District of Columbia. Now, Heller is not an immigration case. It's a Second Amendment case. But what's important about Heller is that it again emphasizes that the word people does not necessarily mean person. Scalia goes into a long history, and in fact, several times interchangeably uses the word people and citizen synonymously, to the point in which, in a case in Massachusetts, the Massachusetts police tried to argue that lawful permanent residents were not included in the Second Amendment at all, because, pointing to Heller, said, hey, people mean citizens. Now, Scalia didn't go quite that far, but he did say law-abiding citizens when referencing people. That law-abiding becomes really important, because what has happened since Verdugo and Heller are two things. One, there have been challenges and successes in the circuit courts that argue that undocumented people do not have any Second Amendment right. And they don't have a Second Amendment right precisely because they cannot be considered part of the people. Now, some courts use more about the language of the fact that they're undocumented, meaning that they are not of a political membership that was part of what was contemplated when the framers wrote the Second Amendment. And then others point to the fact that they broke the law. Of course, they didn't really talk much about the fact that you could be undocumented for breaking civil law, or you could be undocumented for being a child. But nonetheless, courts have said, in several circuit courts, including the one here that sits in the Eighth Circuit, that said there is no protection for people under the Second Amendment because they are not people. Consequently, the case that Rehnquist sort of invited has shown up in several district court cases that have argued that people who are undocumented also don't have a Fourth Amendment right. That they also are not part of the people. And because of that, they do not have all the protections that would be involved with the Fourth Amendment. Okay. So, all right, I wanted to give some time to talk, and I wanted just to point out one more thing. When we talked about, I forgot to mention, when we talked about the deportation power, one of the things that I wanted to emphasize was that the court over the years has recognized what the deportation power means to the people who are deported. And I just want to read a couple of those quotes. Deportation may result in the loss of both property and life, or of all that makes life worth living. Justice Field says, in the Fong Yuting decision in which he dissented, that all such notions imply that brutality, inhumanity, and cruelty cannot be made elements in any procedure for the enforcement of the laws of the United States. Justice Black wrote, deportation as banishment from home, family, and adopted country. And more recently, Justice Roberts recognized that when choosing between prison, long prison sentences, or deportation, it makes perfect sense for the deportation to be the more important consideration when deciding whether or not to go to trial. All right. So let's go back to this. Remember that quote that I said in which citizenship is a right to have rights. Well, those quotes came from a line of cases that were right after the Civil War that dealt with people who were potentially going to lose their citizenship. Perez v. Brownell was a case in which someone had voted in a foreign election and dodged the draft for World War II, and the Supreme Court, in a tightly contested case, decided that he can lose his citizenship that way. But in two other cases, Kennedy versus Mendoza, Trump versus Dallas, the Supreme Court started this doctrine that it was awful. In fact, it was a violation of the Eighth Amendment to take away someone's citizenship, even for a crime. And in doing so, this is a quote that I think is important. The court basically says this: there may be involved no physical mistreatment, no primitive torture. There is instead the total destruction of the individual's status in organized society. It is a form of punishment more primitive than torture, for it destroys for the individual the political existence that was centuries in the development. The punishment strips the citizen of his status in the national and international political community. His very existence is at the sufferance of the country in which he happens to find himself. While any one country may accord him some rights, and presumably as long as he remained in this country, he would enjoy the limited rights of an alien, no country need to do so because he is stateless. Furthermore, his enjoyment of even the limited rights of the alien might be subject to termination at any time by reason of deportation. In short, the expatriate has lost the right to have rights. Why did I talk about that statement? It's because the court recognizes the power of what it means to be deported and what it means throughout. It is, to the court, the loss of rights to have rights. In other words, to this vision of what citizenship means, it means citizenship is the only way that you can claim your rights, while if you're not a citizen, you get the rights that we decide you can have. Okay, Dred Scott, I'll try to get through this really quickly. So I mentioned, of course, Fort Snelling. One of the other important aspects of Fort Snelling was that this was where Dred Scott and his wife, Harriet, met and got married. They were married at Fort Snelling. Dred Scott was owned by an Army doctor named John, I'm blanking on his name, starts with an E, John Emerson. And Dred Scott meets Harriet, they get married, and they have a daughter. They live for a period of time in Illinois, and they go and settle in Missouri. His owner, John Emerson, dies, and Dred Scott and his wife, Dred Scott gets passed, right, to the widow. Dred Scott tries to free himself, tries to pay off the widow, whose last name is Sanford, but the widow decides not to do it, and that's when they decide to sue for their freedom. Why could they sue for their freedom? Well, the Northwest Territories, which is where Fort Snelling was in, and Illinois, which is also was a free state. And Missouri, back in 1836, had recognized that if you, as a slave, were brought to a free state, then you had a right to claim that you were no longer a slave. And the Missouri court had said that in 1836, so Dred Scott sued in the Missouri court for that same answer. Unfortunately, he lost. It wasn't clear why. So what did he do? He decided that he needed to sue in federal court. And so that's how this case ended up in the U.S. Supreme Court. But what's important is you can only sue in federal court if you are a citizen of another state. Now, he could have if he was a citizen of another country, but he wasn't. He wanted to sue for his freedom, and in order to do so, the court had to recognize that he was a citizen of the state of Missouri. His claim was that he was already free, and therefore he was a citizen. And that's when Justice Taney, in his decision, spends most of his time. And most of the decision in Dred Scott was how African Americans who were either slaves or descendants of slaves could never become citizens. And how did Justice Taney get to that position? He talks about the people. He references the Declaration of Independence. He talks about the rights involved with people, and he says Dred Scott and other African Americans would never qualify as the people. Okay, so a couple hopes, this has been very dark, right? A couple things that I wanted to bring up that I think was really hopeful, which is a situation and a story that I'm going to tell that I came across in some of my research, and I really am trying to figure out how and what lessons it can serve. So in 1850s, California really didn't like Chinese people. And they passed some laws that basically said that Chinese people could not testify against a white person. And there was a California Supreme Court case in 1854 that basically said that was true. And then later on, in 1868 and 69, even after the passage of both the Burlingame Treaty and the 14th Amendment, there was another lawsuit that challenged this prohibition about Chinese not being able to testify against white people. The California courts said no, it doesn't matter. Yes, we know the 14th Amendment says person, but we don't think the 14th Amendment was really supposed to overturn state laws and how states were going to run their court system. And so they denied the Chinese this ability to do this. Now, the Chinese community was incensed. They had good reason to be. There were massacres that were happening against the Chinese. And imagine in that situation, it was a murder case. People versus Hall was a situation in which there was a person, a Chinese person, was killed, was murdered by a white person, and the only witnesses happened to be other Chinese people, right? And in fact, the prosecutor on that case was a man by the name of William Stewart, who ended up happening to become one of the first senators of the great state of Nevada. So why is that important? Well, in 1866, the Civil Rights Act, which was the basis for the 14th Amendment, had some language that referenced the civil rights, but talked about citizenship. And of course, the Chinese had just lost a few cases. The 14th Amendment didn't seem like it was going to work. And so there was a delegation of Chinese that met with Senator Stewart and Russ Conklin. Conklin is best known for not only being one of the drafters of the 14th Amendment, but using the fact that he was a drafter to go in front of the US Supreme Court and argue that persons means corporations. But the meeting worked because what ended up happening was that when Congress passed the 1870 Civil Rights Act, also known as the Enforcement Act, it included the word persons. And it recognized that civil rights were supposed to protect not just citizens, but all people, including, of course, the Chinese. Wang Qingfu, I got to read a little bit about him. He was the first person that coined what Chinese American means. He was, well, quite simply, he was a huge activist against Chinese exclusion. He was a really interesting person. The first top is the 1866 Civil Rights Act, and the bottom is the 1870 Act. All right. The last bit that I'm going to talk about and what I think is supposed to be the solutions part of the lecture. Well, first of all, there was a dissent in Verdugo. And the Verdugo dissent was written by Justice Brennan. And Justice Brennan had a completely different take about rights in the Fourth Amendment. And in that take, he then cites to James Madison. And this is relevant because James Madison, this quote from James Madison, was a report on the Virginia resolutions against the Alien Sedition and Friends Act, an act in which a presidential candidate, Donald Trump, has said that he will invoke as soon as he is made president. But in this, James Madison basically said, even though the aliens are no more parties to the law than they are parties to the Constitution, yet it will not be disputed that, as they owe, on one hand, a temporary obedience, they are entitled in return to their protection and their advantage. And Justice Brennan goes farther and basically says, look, rights are not about, the Constitution is not what gives anyone rights. In fact, he makes a point that the founders knew that these rights were from somewhere else. The only thing that was important about those rights was the fact that it was against government power. That if the government has the authority to do something, if the government was arresting and charging that Mexican, then they better recognize that there are limitations on that power, and that is a better way to think about rights. Rights is not some sort of property that we hold. It is much more and much more powerful to think about that as really just limitations on government power. It doesn't depend on who it's being inflicted on. Imagine that scenario that we, unfortunately, I think, are coming towards, which is in order to decide whether or not something can be done, we have to figure out who it's being done against. There was a case in the 1980s of several Cuban refugees who were held in arbitrary detention. I say arbitrary detention because that's what the federal district court found, that they were being held for a prolonged period of time indeterminately, and they were not getting released. And the federal district court in that case said, you know what? Unfortunately, our Constitution does not protect them. We cannot grant habeas based on our federal Constitution. They are, quote unquote, outside of the people that the Constitution protects. But I'm going to recognize recognize international human rights law, and that is going to be the basis for giving them habeas protection. But that is the vision of what the choices we have. And the last point, which is Frederick Douglass, I uploaded his speech. It's in the materials there. It's called the Composite Nation speech. There's a couple things that are really important, but he wrote the speech in 1867, right around when the 14th Amendment was being written, and the Chinese exclusion laws didn't get passed until the 1880s. But there was already talk from Republicans who were his allies, right, who wanted Reconstruction and wanted passage of the 14th Amendment. But there was one particular person that was already running against the Chinese. In fact, he made this huge speech in Boston. And Frederick Douglass wrote the Composite Nation speech and delivered it as an answer to this politician. And it's remarkable because it's very, very similar. Frederick Douglass first talks about how this politician is talking about fear and division. He's talking about how the vision of Chinese invading is not correct. Frederick Douglass then talks about how the United States has plenty of room, that they could house a fifth of the world's population in the United States. And then, importantly, Frederick Douglass talks about his vision of what he calls absolute equality. That what it means to be the United States of America means a vision of absolute equality. I know I'm out of time. I'm sorry. I did not get a chance to share. Let's take a look at your, okay. All right, that means people do value their citizenship. And anyway, I do want to end, by the way, just to say, I didn't know how to end this, except to think about that if we really want to take seriously this vision that the Constitution is supposed to be supporting people with equality, then we really have to revisit the role of the deportation power, because deportation in this little survey, it impacts every single one of the rights that are listed. The right to have a family, the right to have a home, the right to be free, the right to be safe, all of those things are part and an aspect that are impacted by the deportation power. All right, thanks everyone.